Good morning, Mr. Ramirez.
Good morning, sir.
Sir, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Thank you, Your Honor. On April 17th, 2025, in Harris County, Texas, an officer observed a pickup truck change lanes without using a turn signal. The officer observed the vehicle change lanes twice prior to initiating the traffic stop. The officer approached and observed the defendant to be the driver and sole occupant of the vehicle. The officer noted a strong odor of alcoholic beverage emitting from the defendant. The defendant was ID'd by his Texas driver's license. The defendant stated that he did not know how to provide proof of financial responsibility. As the defendant responded to the officer's questions, the officer noted an odor of alcoholic beverage emitting from the defendant's breath. Standard field sobriety tests were conducted. A 6 out of 6 was reported on the HGN, and the defendant stated that he could not perform the walk and turn or the one-legged stand. The DIC was read, and the defendant refused to provide breath or blood voluntarily. A blood warrant was obtained and the defendant's blood was drawn.
All right, pause right here. This moment is huge. The judge is basically saying the officer didn't have enough evidence for probable cause. In DWI cases, odor of alcohol alone is almost never enough. No slurred speech, no bad driving, no failed tests. Honestly, this case was hanging by a thread. What would you have ruled here? Toss it or keep it? Let me know in the comments.
Yeah, may I respond?
Please.
Okay, first of all, Judge, the reason, it's not on there for some reason, but the reason he told the officer he can't do it because he had surgery to his back and to his knee, he can't do it. Secondly, there's no mention of any slurred speech, no bloodshot eyes, no swaying.
I was actually thinking about that as well. All you have is an odor of alcohol.
And then
Anything, there's no accident. It's just a turn. All we have is an odor of alcohol. Is there anything else? Odor alone is insufficient.
No, that he was coming from a tattoo shop and the police officer asked him, is he alcohol because of the tattoo?
Is he what?
He just had a tattoo put on. That's just going. So that's the odor of alcohol.
Come on, man.
That's what. No, that's. I'm just saying. I mean, that the officer actually asked him that question.
What are they? The little alcohol that you put on your skin? You tell me that?
I don't know how it works, Judge. But I've never had a
You're
tattoo.
killing me. You're killing me, Smalls.
Your Honor, the law enforcement officer does state in the DIMS that there is a distinct odor of an alcoholic beverage emanating from the defendant's breath as he spoke.
Okay, yeah.
That's
That it?
all we have before we initiated the standardized post-firing test.
Okay, that's not enough. All right, I'm gonna find no probable cause in your case, Mr. Ramirez. You know,
So
we have enough death on our streets now, you know? $40. One button will get you a car wherever you want to go in this life. You know what I mean?
Yes, sir.
Use it.
Understood.
All right, please.
Thank you.
Thanks, Frank. You are Mark Ramirez. Mr. Ramirez, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir. Okay.
Thank you, Your Honor. On April 18th, 2025, in Harris County, Texas, an officer observed a motor vehicle stopped in the right lane of traffic with its hazards on. The officer approached the motor vehicle and observed the defendant to be asleep in the driver's seat. The officer parked his motor vehicle in front of the defendant's vehicle and attempted to wake the defendant up. Once the defendant was awoken, he allowed his motor vehicle to roll forward and strike the officer's vehicle. The defendant then turned the vehicle off, but failed to put it in park, leading the motor vehicle to roll backwards and strike the other officer's motor vehicle that was on scene behind the defendant's motor vehicle. Once the defendant exited the vehicle, he became uncooperative and was required to be detained by the officers. The defendant would not answer any questions and kept saying, "Oh yeah," over and over. The officer observed a strong odor of alcoholic beverage emitting from the defendant. The defendant declined to participate in standard field sobriety tests initially. Once the defendant was transferred to jail, the defendant stated that he wanted to perform the standard field sobriety tests when asked to perform them again. The defendant was read Miranda warnings and stated that he wanted to speak to the officer. The defendant then stated that he had a 12-pack of beer since he had gotten off of work. The defendant stated he did not know what time it was and what time he stopped drinking.
This is one of those cases where the facts are doing all the talking. Think about it. Asleep at the wheel, car rolling forward and backward, and then admitting to drinking a 12-pack. This is the type of evidence judges love because it speaks louder than anything the defendant could say. Also, notice how the judge warns him about alcohol use right away. That's a huge red flag moment.
The officer observed the defendant to have bloodshot eyes and slightly slurred speech. Standard field sobriety tests were conducted. A 6 out of 6 on the HGN, a 3 out of 8 on the walk and turn, a 2 out of 4 on the one-leg stand. The DIC was read, and the defendant consented to providing a blood sample.
Mr. Ramirez, I'm going to find that there's sufficient probable cause to go forward with the case. If you have a problem with drugs or alcohol, now is the opportunity that you're going to get to address it. If you don't, and it becomes a problem on bond, I'm going to address it for you, and I promise you're not to like the way that I do it. Do you understand?
Yes, sir.
You are not to use alcohol, illegal drugs, unprescribed controlled medication. I'm going to test you like crazy to ensure that you're not using. Any prior DWIs, and does he have a license, please?
Judge, I don't have any prior DWIs, and I'm checking the license right this second.
If you do not have liability insurance and a Texas driver license, you're not allowed to drive, and that is also a condition of your bond.
Judge, we have that his license is eligible.
Okay. Do you have the ability to hire a lawyer, Mr. Ramirez? Do you work? How old are you, sir? Okay. We're going to give you time to hire a lawyer, so I will have you go to Victoria, sign a reset, and then I'm going to have you take your seat in the jury box while we get your bond conditions. A, don't use. Do you understand? You're going to get called to tested. If you fail to appear, I'm going to issue a warrant for your arrest. You understand? All right.
Hello, sir.
Ma'am, you're charged with assault, bodily injury. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you.
Thank you, Your Honor. On April 17th, 2025, in Harris County, Texas.
Right here, you can feel the judge's tone shift. Assault cases with repeat contact are taken extremely seriously. When a judge talks about protecting the community at all costs, that's courtroom code for one wrong move and you're going back to jail. Also, living across the hall adds a whole layer of danger. What would you do in this situation?
Officers were dispatched to an assault call. Officers arrived and spoke with the complaining witness, who stated her and the defendant are neighbors. The complaining witness stated the altercation was only verbal until the complaining witness exited her apartment unit and observed the defendant approach her while calling her names. The complaining witness states that the defendant then struck her 3 times on the head with a closed fist. The complaining witness stated a witness was able to separate them. The complaining witness exited her apartment unit approximately 1 hour later, at which point the defendant approached her again while stating that when the defendant was in jail, she heard the CW was talking bad about her. The complaining witness stated that the defendant then struck her on the face and head with a closed fist 5 to 6 more times. The witness stated he observed the defendant pulling the complaining witness's hair, but did not witness any striking or punches thrown. The officer observed a light red mark on the complaining witness's cheek.
Any alcohol?
Take a closer look here.
Ms. Simmons, I'm going to find if there's sufficient probable cause to go forward with the case. I'm going to tell you now that I will do everything in my power to protect my community at all costs. I don't know what kind of resources you have here, but if you don't have anyone to pony up $5,000 to $10,000 if I revoke your bond, you will be stuck like Chuck in there until this case is over. Do you understand?
Yes, sir.
I don't want you to consume alcohol or illegal drugs, and I don't want you to have contact with the complaining witness in this case. I don't want you to go within 500 feet of where she lives or where she works. You understand?
We live right across the hall from each other.
Don't want you to go anywhere near her. I don't want her to be in fear of when she's trying to get home.
I understand.
Actions have consequences, and I don't want you to go anywhere near where she lives or where she works. You're also not going to possess any weapons as well.
Judge, after taking a closer look, it doesn't specify whether or not alcohol played a role in this event.
Do you have the ability to hire a lawyer, ma'am?
No, I don't. I need one.
Okay, I'll give you an application. We'll see whether you qualify. I need to know everything about you, how much money you have coming in, where from, cars, anything, money in the bank, and then we'll take a look to see whether you qualify.
All right, thank you.
Miranda's going to give an application. You will meet with pre-trial for your bond conditions, then we'll have you meet with someone shortly.
Okay,
Mr. Walker, you're charged with driving while intoxicated, second offense. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Thank you, Your Honor. On April 20th, 2025, in Harris County, Texas, law enforcement officers were dispatched to a report of erratic driving in a gray BMW sedan, nearly striking other vehicles. The law enforcement officer located the vehicle and paced the vehicle going 85 miles per hour and a 65 mile per hour.
Hey, don't talk. Don't talk. Can you start from the beginning, please?
Yes, Your Honor. On April 20th, 2025, in Harris County, Texas, a law enforcement officer was dispatched to a report of erratic driving of a gray BMW sedan, nearly striking other vehicles. The law enforcement officer located the vehicle and paced the vehicle going 85 miles per hour in a 65 miles per hour zone and saw the vehicle almost strike a delineator pole. The law enforcement officer initiated a traffic stop and made contact with the defendant. The law enforcement officer observed a strong odor of an alcoholic beverage, slurred speech, red glossy eyes, swaying, and unbalance from the defendant. The defendant admitted to having 2 beers prior to driving, or 2 alcoholic beverages unspecified prior to driving. Standard field sobriety tests were conducted, a 6 out of 6 on the HGN, a 5 out of 8 on the walk and turn, a 2 out of 4 on the one-leg stand. The law enforcement officer found an open container of an alcoholic beverage on the passenger side floorboard, cold to the touch. The defendant consented to breath and blew a .137 and a .127.
Mr. Walker, I'm going to find that there's sufficient probable cause to go forward with the case. I am now taking away your ability to drive. You are not allowed to drive. Do you understand? You will be signing an affidavit with me today, promising me you're not going to drive. I don't give a rat's behind what your excuse is. If I find that you drive, I can have a contempt hearing. You can be facing an additional 6 months in jail and a $500 fine every time you drive. Do you understand? Because it's a second offense, I'm requiring you now to get a portable device that you're going to take with you everywhere you go to prove to me that you're not consuming alcohol. If I find that you do, I will put you in jail. No more PR bonds for you. Do you understand? You're not to consume alcohol, illegal drugs, unprescribed controlled medication. I'm going to randomly test you. Does he have a license? Can you run it?
Yes, Your Honor.
We're going to reset your case to give you time to hire a lawyer. So I'm going to have you come up here, swear to us that you're not going to drive. I'm going to get you to Victoria where we will have you sign a reset. You will then get with pre-trial for your bond conditions. And after that, you'll be free to go. When you come back, please have a lawyer. Please.
Judge,
Oh, hold on, Vic. Let me tell Mr. Walker one more thing. Come up. I am placing a restriction on your license. You are not allowed to drive any vehicle that doesn't have an ignition interlock on it. I'm sending notice to DPS in Austin so that every single officer in the state knows that if you're in a vehicle driving, that vehicle is supposed to have an interlock on it. If you're caught and you don't have one, they will take you to jail. As it stands now, as part of your bond conditions, I'm warning you not to drive for the time being. Do you understand? Look, it's not, I'm just, no response is required. I'm just telling you what the expectations are. And if you violate these conditions of bond, I will revoke the bond and I'm going to put you in jail.
I know, I'm trying to get a real good understanding. That's why I want to ask the question.
A lawyer, I don't want you to ask something. I don't want you to say something that hurts your case. We're going to give you time, please. All right. Good morning, Mr. Reyna.
Hello, how are you today?
We took you into custody, or we have you in custody now because you are on deferred for an aggravated assault of a family member. And a motion, I'm assuming a motion, let me make sure. Yeah, it looks like a motion to revoke has been filed and you are at a bond denied status now, meaning that you're being held at no bond. So what we're going to do is we're going to do probable cause in this case here. We have to take you into custody. You will probably populate on Monday's docket for the felony court.
For what?
You're now charged with driving while intoxicated.
Now, see, here's the thing.
Oh, did I ask you to say anything?
No, sir.
Okay, please. You have the right to remain silent. Exercise that right. You
Yes,
may
sir.
say something that hurts your case unknowingly when you're trying to think that you're helping. Just don't.
Yes,
We're
sir.
going to do probable cause. Like I said, you have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you. I'm going to appoint your lawyer after we do probable cause to you. You can speak to someone here momentarily. Okay. So let's just do this real quick and then. Okay.
Thank you, Your Honor. On April 19, 2025, in Harris County, Texas, a law enforcement officer conducted a business check of an Exxon gas station. The officer observed a motor vehicle at the gas pump without a front license plate and with the brake lights on.
Start from the beginning, please.
Yes, sir. On April 19, 2025, in Harris County, Texas, a law enforcement officer conducted a business check of an Exxon gas station. The officer observed a motor vehicle at the gas pump without a front license plate and with the brake lights on. The officer observed a male asleep behind the wheel in the driver's seat. The officer contacted the defendant and observed him to have red, glossy eyes and a strong odor of alcoholic beverage emitting from his breath and his person. The defendant initially refused to obey verbal commands to exit the vehicle. The defendant then exited the vehicle and stated that he would not allow any deputies to detain him and would not perform standard field sobriety tests. The officer took the defendant into custody. The officer notes that the ADA accepted charges under no refusal and that a specimen was not needed.
Did anyone see him drive? He's sitting at a pump, he's sleeping. I mean, the officer tried to go look at camera footage to see if they see him driving at all. Does anyone have him driving?
Judge, we do have camera footage from the Exxon recording the defendant driving into the gas station on the dim sum. Yes, Judge.
All I'm asking is, do you have something that shows him driving? Okay. Mr. Rain, I'm going to find that there's sufficient probable cause to go forward with the case. I'm ordering you as a condition of your bond not to consume alcohol, illegal drugs, unprescribed controlled medication. I'm going to randomly test you. If I find that you're using, it's not going to go well.
Yes,
You
sir.
understand? Just don't use alcohol or illegal drugs.
I completely understand.
Okay. Hold on. Does he have a valid license? Can you check, please?
Yes, Your Honor. I will check.
As long as you have a and then does he have any prior DWIs, I guess, as well?
There's no prior DWIs.
Okay. License.
And the license status should be ready for my review. Pulling up. It is trying to load up. It says it's eligible, Your Honor.
Great. Before you say something, let me please give you a lawyer and let me have you talk to the lawyer. And then whatever issue you may have, they can come back and talk to me. I just don't want you to say something that hurts your case in any way. I'm trying to help you, I promise.
You
Yeah,
understand?
just don't. So go ahead, put him back. We'll give him a lawyer, but don't send him down because are you ready for conditions? Okay, take your time. No rush. Okay. You are on bond for a tampering case and you've now picked up a burglary of a motor vehicle. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Thank you, Your Honor. On April 14th, 2025, in Harris County, Texas, a law enforcement officer was flagged down by the complaining witness. The complaining witness advised the officer that a male had just broken into the complaining witness's motor vehicle and drove off in a different motor vehicle. Another witness observed the defendant break into the complaining witness's motor vehicle and provided cell phone video to the police. Additionally, the complaining witness observed the defendant break into his motor vehicle and chase the defendant through the parking lot. The officer pursued the defendant on foot. The defendant was detained and positively identified by both the witness and the complaining witness. The defendant admitted to breaking the complaining witness's window.
What time of day or night was this? Or was it during the day?
It's in the daytime, it appears, Your Honor, but also, like, when you read the summary, it looks like an officer detained him on a bicycle and that he was wearing different clothes from the description of the foot pursuit, that clothes were ditched.
I don't know.
So then they did a drive-by identification of the suspect.
Mr. Robinson, what is the one thing I asked you not to do? The one thing I asked you not to do. Not be a danger to my city or pick up a new case. You've now picked up a very I'm going to find that there's probable cause to go forward with the case, and I'm now going to put a monitor on you so I know where you are at all times. If you get out of custody, because now I'm revoking your bond, you will go to jail. If he gets out, GPS monitor not to go within 500 feet.
He has a GPS monitor on him.
Putting him in custody. No alcohol, no drugs, no weapons, no going within 500 feet of where the complaining witness lives were. And I'm going to tell you now, because I don't know if you're going to get out, but if you do, you endanger my city again, I'm going to go ballistic on all of your bonds. Do you understand? Goes with you.
I have
Judge, I have no reason to doubt that,
Scott, just, there's no need. It's done. Every time you take off and when we revoke your bond, all you do is you're giving money to bonding companies. You just enrich bonding companies. That's all you're doing. I don't know if you got a lot of free money, but if so, I guess we'll stick with the conditions that we had before. Just no contact with the complaining witness, no weapons. So do you have an offer in this case now?
We do.
Okay, so we're going to set your case for trial today. You must appear for trial date, 8:30 in the morning. Don't appear at 12, not at 1, and then we'll be set. I guess May. Let's see, today's what, 25? May 27th, okay with you?
Judge, that's a short week.
Oh, yeah.
June
about-
10th or May
What time do
20th.
we have on the 3rd, Ramona?
I'm sorry.
What about the 3rd?
Victoria's out that week.
June 10th. Is June 10th a holiday week too?
Yeah, we can make it a holiday week.
No, no. You're tentative.
No, Juneteenth, Judge.
Everybody's a comedian.
Thank you, Judge.
Voting.
Thank you.
Thank you.
We're gonna have a side petition.